Have you been thinking about getting your estate plan done, but you're confused about whether you need a will with or without a living trust? In this video, I'm going to help you figure that out by telling you 4 key things you can do with a trust that you can't do with a will, right now. I'm Greg Gordillo. I've been a lawyer for more than 25 years, and I'm here to give you tips and insight into how to use the law to keep your family and everyone you care about out of court and out of conflict if something should happen to you. Now about that. Both wills and trusts are estate planning documents that can be used to pass your wealth and property to your loved ones upon your death. However, trusts come with some distinct advantages over wills that you should consider when creating your plan. Now that said, when comparing the 2 planning tools, you won't necessarily be choosing between one or the other. Most plans include both. In fact, a will is a foundational part of every person's estate plan. But you may want to combine your will with a living trust to avoid the blind spots inherent in plans that solely rely on a will. If learning more about what makes a good and effective estate plan interests you, consider subscribing to this channel. And if you're thinking about hiring a lawyer to help you with your estate plan, stick around to the end and I'll tell you how you can get a free book to help you make the right choice. Now, when it comes to choosing between a will-based estate plan and a trust-based estate plan, here are 4 reasons you might want to consider adding a trust to your estate plan. The first reason you might prefer adding a trust to your estate plan is avoidance of probate. One of the primary advantages a living trust has over a will is that a living trust does not have to go through probate. Probate is a court process through which your assets left in your will are distributed to your heirs upon your death. During probate, the court oversees your will's administration, ensuring your property is distributed according to your wishes, with automatic supervision to handle any disputes that might arise. Probate proceedings can drag out for months or even years, and your family will likely have to hire an attorney to represent them, which can result in costly legal fees that could even drain your estate. The bottom line? If your estate plan consists of a will alone, you're guaranteeing that your family will have to go to court if you become incapacitated or when you die. But if your assets are titled properly in the name of your living trust, well, your family could avoid court altogether. In fact, assets held in a trust pass directly to your loved ones upon your death, without the need for any court intervention whatsoever. This can save your loved ones major time, money, and stress while dealing with the aftermath of your death. Now, the second reason you might prefer adding a trust to your estate plan is privacy. Probate's not only costly and time-consuming, it's also public. In fact, once in probate, your will becomes part of the public record. This means anyone who's interested can see the contents of your estate, who your beneficiaries are, as well as what and how much your loved ones inherit. And that makes them tempting targets for frauds and scammers out there. Using a living trust, the distribution of your assets can happen in the privacy of our office, so the contents and terms of your trust will remain completely private. The only instance in which your trust would become open to the public is if someone challenges the document in court. Now, the third reason you may prefer adding a trust to your estate plan is a plan for incapacity. A will only governs the distribution of your assets upon your death. It offers 0 protection if you become incapacitated and are unable to make decisions about your own medical, financial, and legal needs. If you become incapacitated with only a will in place, your family will have to petition the court to appoint a guardian to handle your affairs. Now, like probate, guardianship proceedings can be extremely costly, time-consuming, and emotional for your loved ones. And there's always the possibility that the court could appoint a family member you'd never want making such critical decisions on your behalf. Or the court might even select a professional guardian, putting a total stranger in control of just about every aspect of your life. With a living trust, however, you can include provisions that appoint someone of your own choosing, not the court's, to handle your assets, if you're unable to do so. Combined with a well-drafted medical power of attorney and a living will, well, a trust can keep your family out of court and out of conflict in the event of your incapacity. That's not something a will can do. Another advantage a trust has over just having a will is the level of control that a trust offers you when it comes to distributing assets to your heirs. By using a trust, you can specify when and how your heirs will receive your assets after your death. For example, you could stipulate in the trust's terms that the assets can only be distributed upon certain life events, such as the completion of college or purchase of a home. Or you might spread out distribution of assets over your beneficiary's lifetime, releasing a percentage of the assets at different ages or life stages. In this way, you can prevent your beneficiaries from blowing through their inheritance all at once, and you can offer incentives for them to demonstrate responsible behavior. Plus, as long as the assets are held in trust, they're protected from the beneficiary's creditors, lawsuits, and divorce, which is something else wills won't provide. If for some reason you don't want a living trust, well, you can use what's called a testamentary trust to establish trusts in your will. A testamentary trust won't keep your family out of court, but it can allow you to control how and when your heirs will receive your assets after your death. Now, I'm guessing you're watching this video because you were thinking about getting your estate planning done. Good for you. Plenty of people don't even get that far. Now, you've gotten to the stage where you want to make an informed decision about what your plan will look like. Again, good for you. Now, some people also get to this stage, but they never take the next step of actually getting something done. You know, I'm always curious about that. What is it that prevents people from actually getting their estate plan done? If it's not too personal, let me know in the comments. What's the biggest obstacle you've had to getting your plan done? In the end, the best way for you to determine whether your estate plan should include a living trust, a testamentary trust, or no trust at all is to meet with someone like me, a family business lawyer, for a family wealth planning session. During this process, we'll take you through an analysis of your personal assets, your family dynamics, what's most important to you, and what will happen for your loved ones when you become incapacitated or die. Sitting down with a family business lawyer to discuss your family planning needs will empower you to feel 100% confident that you have the right combination of planning solutions in place for your family's unique circumstances. Now, as promised, if you'd like help with choosing the right lawyer to help you, well, click on the link below and you'll be able to get a free copy of a best-selling estate planning book. It's called Wear Clean Underwear. It's an easy-to-read book of 3 short stories about estate planning gone wrong and how it could have gone right with a different lawyers helping. I hope you found value in this video, and if you did, hit the like button for us.